Well, hello there. How is everyone? I hope you are all well on this stupendous Sunday. And I'm coming at you pre-Sunday dinner. So I know that a lot of us have got stuff to do today, so I'm going to get straight into the meat and potatoes. But may I just say that you are looking absolutely amazing today. So you must be having a good weekend. And if you're not, don't worry about it. It's not affecting you. We've got some docs to go over. There's 3 or 4 new docs. To find out how much Ann Taylor is actually getting paid. Getting paid. You know me in English, we're not friends. But anyway, so we have a look at them. Let's go to doc number 1. I know some of you love these docs. I love these docs when my buttons work properly. So we have a look. So this is doc number 1. So we are looking at an order set and deadlines and hearing. So we've got more deadlines coming up. This is probably the most boring of the docs, to be fair. So based on the February 28th, 2024 hearing, the court orders the following. So this will help people who didn't have the time to sit through that debacle the other day and learn what actually came out of it. So any notice of defence of alibi must be filed no later than April 17th, 2024. If defendant intends to offer a defence of alibi, the notice must comply with Idaho Code Section 19-519 and shall state the specific places at which the defendant claims to have been at the time of the alleged offence, and the names and addresses of the witnesses upon whom he intends to rely and establish such alibi. Bethany Funk. We'll get to that tomorrow. A hearing on defendant's motion of change of venue will be held on May 14, 2024 at 1:30 p.m. Pacific time. The hearing will be in person, open to the public, and streamed live on Harsh Reality channel. I got so excited then. Defendant's brief witness list and any evidence the defence wishes to present in support of the motion for change of venue must be filed by April the 17th, 2024. The state's response brief, witness list, and any evidence in opposition to the motion must be filed by May 1st, 2024. The deadline for the state's discovery to be turned over to the defence is September the 6th, 2024. So I like the fact that like the alibi and all of that has got to be sort of April, but even after we've waited this long, we're now being given basically, we're talking about the going towards the end of the year. September the 6th, we'll be thinking about fucking Christmas again. Do you know what I mean? Why is the deadline for discovery, the state's discovery, so far away? It's fucking wrong. It's not right. Not when they've had this long and they've been asked this many times. Anyway, I thought I'd be a bit more chilled today. The deadline for the defence's discovery to be turned over to the state, including mitigation, is January the 9th, 2025. Obviously, that date is based on the fact that they're given the prosecution till September to give them what they specifically need in order to get this done, which is just pushing this trial further and further down the line, isn't it? Further down the line. So anyway, that's doc 1. So if we come back up here, let me go to the next one. So we present. Let's have a look. Present. We're gonna go stop that screen. We're gonna present. Share. We're going to go over to the next one. Which one shall we have next? I reckon this one. This is a good one. Share. Are we on? Yeah, we're on. So what's this? This is response to the public records request. This is a doc and a half. I'll tell you. This is a doc and a half. So response to public records request. A public records request was submitted to the LATAR or LATAR, I know some of you say, a county clerk on February the 26th, 2024. It was subsequently forwarded to this court for review and a response. The request was to examine and or copy records pertaining to the total cost to date of the case against Brian Kohberger, including both defense and prosecution, and any other cost this case has required. Pursuant to code, blah, blah, blah. This response is specific to records of the Latah County Judicial Department, more specifically, records for which this court is the custodian judge, as defined in Idaho court, blah, blah, blah. The Idaho, blah, blah, blah. I hate all these numbers. Any public record of the state, however, Idaho code exempts from disclosure records contained in court files and judicial proceedings, the disclosure of which is prohibited by or under rules adopted by the Idaho Supreme Court, but only to the extent that confidentiality is provided under such rules. Idaho, blah, blah, blah. Examination and copying. Exemption from and limitations on disclosure rule allows a judicial record to be sealed. So this is just talking about what, based on what has been requested, how they can get over giving some of that information out. Well, we only have to tell you this because we have to, and we don't have to give you this because this rule says that we don't have to give you that. So that's that. So let's just skip forward to this next bit. Right. So on January the 13th, 2023, the resource judge tasked with evaluating and ruling on any defense requests for services issued on order sealing documents pursuant to Idaho Court Administrative Rule to preserve the right to a fair trial. Therefore, all documents and materials related to costs associated with the defendant's request for services are sealed and exempt from disclosure. So even where the money is going and what they're spending things on is under the gag order. They don't have to give that information either. So whoever's done this request, they're not getting the information and they're hiding it. It's very much like where's the autopsy results, again under seal. But we saw autopsy results and stuff in any other case, pretty much any other case that we've been dealing with, haven't we? The 911 call. We can't see any of the. I know this is an ongoing case. I know people are going to turn around and say, but it'll be interesting to see what actually exists when all the dust settles in this. In addition to this response explaining why the Latah County Judicial Department cannot provide the total cost to date of the case against Brian Kohberger, attached is the above mentioned order appointing resource judge and order sealing documents. Additionally, the order this is funny though. Order approving appointed counsel's hourly rate, which is not a sealed document. So all of the stuff except what Ann Taylor's getting paid. So that is just to fuel some fire, and that's going to fuel some flames. We'll come to that in a second. So there we go. Look. So request to examine copy public records. Print name. So this was John Webb, KHQ TV. I hereby request to examine so this was the John Webb of KHQ TV who sent in the request. So public records request. But check this out, look. So Ann C. Taylor, Chief Public Defender of the Kootenai County Public Defender Office, has been appointed to represent defendant Brian C. Kohberger at public expense. Therefore, it is ordered that Ann C. Taylor is entitled to payment for her services at a rate of $200 per hour. And J.W. Alston, Chief Deputy of Litigation, also of the Public Defender Office, will be entitled to payment for his services at a rate of $180 per hour. And then we've just got some other bits and pieces here. I think that's pretty much it. It is ordered that Mark Monson, District Judge, Nez Perce County, is appointed as the resource judge for any defense requests. It's just got some different bits and pieces here. And District Court, blah, 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 blah. This map full of seal certain documents. So again, this is just what they're not going to hand over. Which standard form they don't like handing fuck all over, do they? They don't like handing a lot over at all. And then I think there's one more doc here. So let's have a look at the last one, which I think was here, which is the amended This is to do with the IGG. We're back into the IGG information. So we know that it kind of kicked off in there in the court regarding the IGG stuff. So based on the February 28th hearing, the sealed order for disclosure of IGG information and protection order is amended as follows. So it's just naming specifically who has access to the IGG information that has been set forward for them. So Ann Taylor, Jay Logston, Eliza Masseth, Brian Koberger, and the IGG defence experts Leah Larkin, Vic Barlow, Stephen Mercer. They may view the IGG material provided by the state, any further dissemination of the materials, or the information contained within the materials, including any investigators, must first be approved by the court. And why is that? What, so the prosecution can get hold of them first? I don't understand why they've got so much control over who the defence has the ability to go and show things like this to. Why do they have to know in advance and be approved? As long as somebody can be shown something and then prove that it was right that they were shown, I don't see the problem. This seems to me just a massive controlling. You tell us who you want to show, we'll go and have a chat with them and tell them how. Again, I'm just a bit more. Additionally, no individual on the family tree who was not previously known to the defence via the defence's own investigation may be contacted by the defence or any agent of the defence without prior authorisation from the court after showing as to why such contact is necessary and material to the preparation of the defence. The defence mitigation expert who has created her own family tree and who does not have access to any of the IGG information may continue her mitigation investigation, including contact defendants' immediate family members and other related individuals. Now, I know there's going to be a lot of people who feel that, like I feel that it was tipped off. The way they got to Brian Coburg was a tip off. A lot of people have thought maybe that was someone in Brian Coburger's family, maybe his sister tipped him off. And I'm on the fence for that because I do feel that there's a potential that someone did. I wonder whether that was why Ann Taylor questioned whether she was able to contact Brian Coburger's family. This is another thing, these little nuances, these small little details, the devil's in the detail. Now, if Brian Koberger genuinely didn't do this and he's thinking, well, it looks like someone fucking dobbed me in, is he even contemplating that it was his family? And has he and Ann Taylor had this conversation? And is that why she put that forward? Because if his sister, for instance, was a protected witness, then would they be given access to her? And were they tested? Were they feeling the waters out? I don't know. Let me know down below. But they are the latest docs. We've got some stuff coming up next week with regards to the Idaho 4 case. We will still be touching on the Idaho 4. I'm not letting go of the Idaho 4. I'm just conscious that there are other cases that people want to get seen. I'm also doing the Remembering series, which we're going to be doing bi-daily lives, touching on some of the cases we've previously spoken about. And also, I am with a Convicts Fort with AR Hayes on Thursday at 10 p.m. UK time, 5 p.m. Eastern time, which can't remember Pacific time on that. I think it's like 3 hours earlier. Is that like 2? It's in the community feed. Go check it out. Anyway, for now, go and enjoy the rest of your Sunday. Have a day of rest. I'm on live later on tonight. Don't forget, 10 p.m. this time, 5 p.m. Eastern time. Don't ask me Pacific time. I can't work it out in my brain. It's too early. And yeah, but I'll catch you later over here on a live for those who want to come and join in. But until then, I'm out of here, I think, if I can press some buttons and get out of there. But yeah, that's it. Take care. Look after yourselves. I'll speak to you all soon.